Dear colleagues, our audience who listen to us on YouTube, we are ready to go to the fourth lecture within our third Congress, Mozolin readings on comparative law. This lecture we hold, let's say, on two areas. First will be about arbitration, legal protection in the state legal protection system, and we have our speakers, one of the main specialists both in Russia and Austria on the issues of digital arbitration and litigation in the digital age. We have Christian Aschauer, professor of arbitration law, Karl Franz University of Graz from Austria. He has many years of experience being an arbitrator and an advocate, and he's our great friend. He's also an author of multiple works on the topic of arbitration in the digital age. The second speaker today is Elena Streltsova, an associate professor of the Department of Civil and Administrative Justice at the Kutafe Moscow State Law University, candidate of laws. She's also an author of multiple publications and several works dedicated to the issues of informational technologies in state legislation and the changes in the alternative dispute resolution means, because this is a direct link which we need to take into account, especially when we speak about the issues of online dispute resolutions. This lecture is called, as I already mentioned, Arbitration and Litigation in the Digital Age, and we are ready to pass the floor to our dear speakers.
Many thanks for the very kind introduction and for inviting me. I'm very honored to give a short presentation, and with my colleague, Professor Streltsova, I agreed that I should cover the following topics: the making of an electronic arbitration agreement, the commencement of the arbitration in an electronic environment, the use of social profiling for the purpose of constituting the tribunal, the exchange of written submissions in the course of an arbitration, the use of video conference technologies, deliberations of arbitrators, the taking of evidence, and the making of the award. I have only very little time, and I will be brief and limit myself to the presentation of the outcome of my analysis. Let us start with the electronic arbitration agreement. Today, it is a matter of due course that contracts are concluded electronically, and that these contracts will also contain an arbitration agreement. And here, the conclusion of the contract and the form of the arbitration agreement are in conflict, because we have naturally a requirement of form for the arbitration agreement. But if we apply the New York Convention, we have the following situation: that the New York Convention was groundbreaking back in 1958, in as much as it allowed the conclusion of an arbitration agreement by telegrams. A telegram does not have to be signed, and therefore we can also interpret the New York Convention so as to allow the conclusion of arbitration agreements by an exchange of emails, because emails do not have to be signed either. We may have an issue if we have an arbitration agreement that is contained in a traditional contract, because even under the New York Convention, this contract must be signed by the parties, and we must discuss and analyze what is a signature within the meaning of the New York Convention. But here it should be possible to apply a very open interpretation and to find that we have a signature in every case where the signatory is identifiable and where the declaration of the signatory can be attributed to the relevant person. And this must be assessed by a case-by-case basis, but I submit that standard IT applications can produce such a signature. So I think this issue is largely dealt with. When we come to the commencement of the arbitration, we can only also see that over the past 2 years, the most important arbitral institutions have all amended their practices and make it possible in the meantime to commence the arbitration by an electronic request for arbitration. I can refer, for example, to the ICC Arbitration Rules 2021. The claimant has to file only an electronic copy of the request for arbitration. A paper copy of the request for arbitration will only be filed where it is strictly necessary to hand over a paper copy to the respondent in order to safeguard the respondent's right to be heard. But in very many cases, the respondent will reply to the electronic request for arbitration, and the paper form is only needed when we have a concern that the respondent will possibly go into hiding. So I believe the practice has evolved to allow the commencement of the arbitration in purely paperless form. And by the way, this is also the most practical form, because the digital documents can be handled much easier by all the parties and by the arbitral tribunals. When we move on to the constitution of the arbitral tribunal, I believe that in the modern digital world, here we may have a real issue, because possible arbitrators leave a lot of information about the professional career in the internet, but not only. There will also be information about the private matters, for example, their preferred holiday destinations and what not. And perhaps it will be possible for algorithms to combine all this information and to use this information for the prediction of the possible outcome of the arbitration. I think that here we may see revolutionary changes in the future, and here we may have an issue, and here we must really be careful to avoid negative consequences. When I can move on very briefly to my next issue, the exchange of written communications during the procedure. Here too, our practices have evolved a lot over the past 2 years, and the exchange of written submissions by email has become the norm. And in addition, we see that arbitral institutions in the meantime offer secure data rooms, which are extremely helpful to guarantee safe communication. Safe within the meaning that the communication channels cannot be, the communication cannot be amended, and confidentiality, this is very important, is ensured. And this is a technology where each side downloads the submission and the written evidence on a platform, and all the participants are informed by email that a download has been made, and they can immediately see the new document, the new evidence. These kind of secure data rooms are offered, for example, by the Stockholm Chamber of Commerce, the SEC, the VIAC, ICSID, and CIETAC. This is also an example where we can see that modern technologies can be integrated very well in the arbitral procedures that we know. My next issue, which I discussed with a colleague, Professor Streltsova, are video conferences. And this is perhaps a huge issue where we see that our practices have changed enormously over the past 2 years. Let me share only a few thoughts. The first thing is that even if the whole arbitration is conducted electronically, nevertheless, there has to be a seat of the arbitration. The seat is a purely legal venue, but it is necessary to assess the jurisdiction for a possible setting aside of the arbitral award. So even if the whole procedure is conducted electronically, the institution or the tribunal in an ad hoc arbitration, as the case may be, will have to determine the seat of the arbitration. It is a procedural question as to whether the hearing must be conducted in person or whether it can be conducted by video conference. So in the first place, it is up to the private autonomy of the parties. The parties may agree that a possible hearing shall always be in person, and in this case, the tribunal will have to enforce this agreement. Conversely, the parties may always agree that the hearing must be by video conference. But here I would submit that in all circumstances, a tribunal retains the inherent power to order the parties to appear in person where this is necessary after consultation with the parties. And here I'm thinking of hopefully very rare cases where parties might try to create a kind of, you will have read about this technical possibility, a deep fake witness, a kind of avatar, a person who is perhaps a lawyer and speaks with the voice or with the face of another person, and that can be transmitted by video conference. Who makes sure that the person who is speaking now to you is the real Christian Aschauer? So to avoid such kind of criminal behavior, I think a tribunal, if there is, if this is the case, must have the power to summon witnesses and parties in a person. So The latest set of institutional rules, and here I refer, for example, to the LCAA Arbitration Rules 2020, to the ICC Arbitration Rules 2021, or to the VIAC Arbitration Rules 2021, expressly state that it is within the discretion of the tribunal to decide whether the hearing shall be in person or whether it can be by video conference. And importantly, these are only different forms of organizing a hearing which are at the same footing and which are equal. We had one case that was decided by the Austrian Supreme Court in 2020, where the parties made no agreement as to the issue, is the hearing by video conference, is it in person? The tribunal ordered a hearing by video conference against the objections of one of the parties. The party challenged the tribunal, and the Supreme Court subsequently found in the challenge proceedings that the decision of the tribunal was in order. It did not allow the challenge, and it said, I think very reasonably, that we must balance the different interests. And there is an interest to have a hearing, and the hearing is a mandatory right under Austrian law. A party has a right to a hearing, but this right can also be safeguarded by a video conference hearing, because under, and here the European Convention of Human Rights comes into play, under the European Convention on Human Rights, there is also a right of every parties that civil rights shall be disposed of within a reasonable deadline and within a reasonable time limit, and therefore under certain circumstances, a video conference hearing is unavoidable. If we have a video conference, we will automatically have a recording of the video conference. And then we have an issue whether this recording may be used for the purpose of, for example, deliberations, whether the tribunal is allowed to look into the recordings, for example, of a witness examination, or whether it is only allowed to read the protocol, the verbatim of the witness examination. I would submit that in principle, the tribunal is not allowed to look into the recording without prior consultation with the parties, because the recording is a means of evidence in its own right, and the parties must have a chance to comment on this means of evidence. I have one issue with video conferences, and that is the deliberations of the tribunal. I found it in practice not very easy to organize a deliberations meeting also only by video conference. The deliberations of the members of the arbitrary tribunal are very important, and more important, I would submit, if we compare this to state court proceedings, because the state court judges who are sitting in one and the same panel, they know each other, they have the same legal training, they speak the same language, whereas arbitrators are from very different legal backgrounds. And therefore, the deliberation process in an arbitration is so extremely important. And it is an ongoing process. It starts with the first letter to the parties and ends with the signing of the award. And sometimes it also needs a bit of informal atmosphere around the kitchen table, for example, of the president of the tribunal. And this, it's very difficult to reproduce this in an electronic setting. Do I have a few more minutes? Can I ask? My next issue would be the taking of evidence. And I think here we see the following. We see a proliferation of emails. In the past 2 decades, I think our communication behavior has changed massively. No one is making telephone calls anymore. Everyone is working based on emails because it makes it possible to work in an asynchronous way, but nevertheless in a timely fashion. We can work over different time zones. And those emails are distributed to many recipients, and the emails are usually stored on many different servers over a long period of time, and therefore they can be downloaded again and used as electronic written evidence. And very often it is surprising how well it is possible for the tribunal to reconstruct past events, negotiations, for example, on the basis of emails, provided that the emails are available. And what I see in my practice is that the attention is shifting from oral evidence to written evidence and email evidence. And the matter, very often the controversial matter is who has an obligation to submit emails. And then we have issues in document production proceedings. And we have also new technical tools to deal with these huge volumes of emails, search engines, for example, or modern data management systems. So I believe that oral evidence is perhaps less important, and it will be needed only usually to confirm whether an email is authentic, or just to put a face to a corporation. There would be other issues, but to move on, let me conclude by referring very quickly to the award. Under Austrian law, and I presume the same will be true under Russian law, the award must be issued in writing. And this implies that the award the tribunal must express itself in words. Yeah? For example, you might ask, will it be possible in the future to read an award and then you have a text, a hyperlink, where the tribunal says, we do not believe that the following statement of the witness is true. You open a hyperlink and you see a video where the witness makes a statement. I think this is not possible. It would not comply with the writing requirement, with the requirement that the award must be in writing. And here we can see that the written method has also an advantage because I would submit it helps the tribunal to be more objective, to be more nuanced. But this must be distinguished from the question whether the award can be signed electronically and whether the text can be stored electronically. And here, let me be very brief. If the place of arbitration is, for example, Austria, it is possible to store the text of the award in an electronic PDF document. In principle, this is possible. It is also be possible to sign the award electronically, and we have the equivalent of the handwritten signature also in the electronic sphere. It must be a qualified electronic signature where the identity of the signatory is confirmed by a secure data provider. This is possible. It would even be possible to put an electronic apostille on the award. So this is possible, I say, in theory, because very often by the time the award is signed, we do not know where the award will have to be enforced and what are the requirements and the practices of the enforcement court. And therefore, very often the parties are on the safe side and the arbitrary tribunal, and the award is simply made in the traditional way with a handwritten certified signature. Uh, so this brings me to the end of my very short tour d'horizon of the present state of the practice as I see it, and I'm very much looking forward to the explanations of my colleague.
Большое спасибо, господин Aschauer. Мы точно
Thank you,
понимаем.
Mr. Aschauer. We do understand that you are not an imposter. Obviously, only you can speak that interestingly. And I thank you for the questions you raised, because you actually made it easier for me to speak about this theme, but regarding the state courts, in the sense that you touched upon the issues of electronic litigation and proving issues and notification and the presence of the parties, or maybe their personal presence or video conference presence. All these problems exist in state courts as well. But we also have something else, like what makes digitalization of state courts something specific compared to arbitration courts. So what is this specificity? Arbitration is also an agreement between the parties. It's they decide on their own that they agree to go to this specific court by this proceeding according to these rules. To the contrary, state court is in a different niche. State court, well, usually people cannot go to private arbitration. It's the state has to provide this service, and it turns out that state court digitalization has some specific aspects, which means there must be an agreement between the state and the private person on the way how this segment must be digitalized. So what do we have now? Just briefly, for those who might not be aware. As of now, and I will speak about the Russian Federation, Russia has adopted a program on machine readable law, and for the last 2-3 years, during the pandemic especially, we've started to actively use all the possible ways to implement even some simple digitalization. For the courts, it's notification via Gosuslugi website, which additionally guarantees the correctness of the notification, and it's actually a very good service in that sense. In terms of lawsuit, there is a way to file a complaint. You can use specific websites to file this complaint, where you will calculate, the machine will calculate the cost of this complaint automatically. You will not have to work with lawyers, and maybe you automatically will be given specific court for your case, which is also very, very good. Digital signature obviously exists and can be used. Automated at the level, well, we have some pilot projects for automated prompt to people who file their complaint. The machine would give them a prompt, what else they need to do, what else they need to fill in, electronic case, as of now, can be both in the court or well, maybe the case itself. We have electronic version of the case and we have the printed version of the case. So as of now, it's a little bit of a redundant work. We have both the printed version and electronic version. So we're not really sure about the value of this electronic version, but there could be a transition later on. We could also add some documents which you could pass from one court to another entity via the electronic form. But we do have some problems, and I mean some global ones. Obviously, law enforcement is a very sensitive part and relation between the state and society. And I must say that in our country, sometimes it's a very problematic issue. And one of the first issue is the capability to solve, to use digitalization, the access to judicial system. Can we do this? Well, obviously we can say, yes, we can do this. There are some mechanisms which make it possible in a more simple way. You can do it from your home, you can use the internet, and you've already mentioned some of these problems, but it makes it easier to file a complaint, to go to court, especially taking into account the scale of our country, which is very important actually. But on the other hand, and we say about it many times, we need specific equipment, both from the state court side, but also from the other parties. It's not about devices, it's not just about computers, it's also the payment of tariffs for the internet. And in our country, it's not that expensive, but during the pandemic time, the prices have changed. Now there are fewer people who would buy broadband internet, for example, by about 10%. So this is also one of the difficulties.
And the issue of how they take decision in court, if we talk about transparency of decision-making process, digitalization is capable of giving another chance for us to give an opportunity to make courts more independent, also through decision making, through usage of blockchain, when interference into decision making can be seen in some chains. Another thing that is related to more large-scale prospective plan is transforming of law for court protection. Digitalization, which penetrates in our relations more and more in this or that way, will result on the one hand to Internet of Things, on the other hand to problem related to allocation between the issues which are quite simple related to facts and complicated issue. If we talk about elementary algorithm, it's quite obvious that quite soon we'll come to the point that part of the issue will not be considered by state judges. This will be totally automatized resolutions. Now, at the level of automatic preparation for this decision making, we have projects in one of the regions of Russia, and I know that it is also present in other countries of the world. And I believe that in real life, this kind of digitalization can make a question in the future whether all the legal relation can be protected only within the frames of the court process. It's an important question because correct legal protection is one of the components of basic values which are of utmost importance. In this respect, the court can leave a whole sphere of relations and disputes which are considered. At that, with the remaining part, there will be again a problem related to the issues of fact. Digitalization, which was mentioned by Mr. Aschauer as confirmation of these or that facts, is related also to the possibilities of distortions at the level of information input, distortions at the level of manipulation and distortion of saving information, but differently to interference that we can detect at the level of a written document when something is being corrected and what is easily identified at the level of expertise. In the issues of documents which were done only in digital way and for digital transactions, if these are not blockchain systems, so we can say that we will be in the area of problematic detection of the authenticity, and will have another problem, the correction of these mistakes. And these mistakes and the order of their correction also creates additional, a very severe problem of the state court. Now I'm talking about the state court, because it's obvious that legislation, that justice, which will not meet actual conditions of the case and the dispute will be resolved, it will not be a legal resolution, regardless of whatever we call it. Another issue that is also related to state court is understanding of state court, at least we understand it in Russia this way, as an element of state management. And in this respect, court that is a subject of big data reception can accumulate through itself for the state huge amount of information, huge layers of information, and they are absolutely diverse. These are issues regarding the subjects of dispute, their active operation, the facts that belong to the evidence for court. It can be transformed, studied, and analyzed in an absolutely different way. Here, I would like to tell you that even commercial giants like Google and Amazon for now do not possess the same capabilities that a state court can possess, getting that amount of information that it is going to belong to it. But I should say that the day before, one of our digital monopolists and at the same time enthusiasts, Sberbank, the platform of Sber, represented a new service where parties can lend money privately, but detect it at the platform of Sber. I understand that this is another element of collecting information. So this information, when we're talking about a commercial structure, we understand that this information is collected to somehow offer goods, services, get orientation to our habits so that to sell in a better, in more interesting way, what we want to sell to this or that company. But that is related to even more complicated issues. And namely, in this issue, we have not reached agreement between a state and a society. And I don't know some severe limitations in the world which would make it possible for the state to have efficient limit in this respect. I believe it's a very important thing. So, as to information management, another issue that occurs, and for us it's a very painful question because traditionally a lot of attention paid to it. This is issue of information security. Information security, in particular of its correct usage or loss of information, and also refusal of court protection for some population, because part of the population is afraid to provide information because they believe that later this information will be used in an incorrect manner. That is especially dangerous because it can result in a marginalizing of a society, a considerable part of society, and the state also requires specific mechanisms, specific guarantees, which would not only provide for this security, but also recover the distorted non-material well-being which results due to information revelation. And this is also a sensitive part as long as real and efficient mechanisms are not found yet. Actually, I would like to tell that now we are in a very interesting area of development of state courts. On the one hand, we see that more and more convenient is addressed to court. But on the other hand, the faster we move on towards this direction, the more we have global unsolved issues that can finally result in complicated problems later on. And I believe that these complicated problems should be solved now. And it's not only related to legal resolutions, these are also technological solutions and partially when we talk about security. This is briefly what I wanted to share. Thank you. And now I think we should discuss the issues that we have during analysis of problems of arbitration and state courts and their interconnection. Mr. Aschauer, out of what we have discussed, number one, the first question that occurs whether the principles, the fundamental principles of arbitration are compatible with using of information technologies. In your opinion, is there compatibility in this issue or is it not possible?
I think in principle, yes, if we refer to the principle of equality of the parties and procedural fairness. I think that in principle, an arbitration is a forum where even in our technological advanced environment, we can offer to the parties fair and equitable proceedings in principle. But what you said now is what we must keep in mind also for arbitration proceedings. You rightly referred to the authenticity of documents. This is a challenge for parties in an arbitration and also for tribunals. There may be manipulations of electronic documents. Arbitrators will have to be in the future IT specialists, and they will have to learn about possible manipulations. And as I said, this may also happen if we have witness evidence that is taken by video conference. Here too, we may have challenges in the future. And the other is what you rightly say, data protection. Arbitrary tribunals have huge volumes of data and information, and very often very sensitive and confidential information. How do we deal with this to make sure that nothing can be leaked? This is another challenge. We have in many, within the European Union, we have the European Data Protection Regulation, which is now slowly, it's starting to be implemented. And it has many challenges for tribunals and parties. And it is a big issue how the requirements will be applied in an arbitral setting. So to make a long answer short, you are right. It is, I believe it is possible in principle to offer fair and equitable proceedings, but still it is a challenge, and we must be careful about the potential of abuse in the future.
Thank you very much for your answer. I think I would not say that without talking about fundamental principles, but even a little bit on top of those, I would say that arbitration for me is one of the symbols of freedom of personality while choosing the way of its protection, whether to address to state court or to non-state court. And I believe that what digitalization represents, the risks that you, Mr. Aschauer, have fairly mentioned, which is related to specific features of confidentiality typical of arbitration, well, the very opportunity to turn to arbitration and also exterritorially choosing the court where physically a person would not be able to address supports this idea of freedom of a person to choose between state and non-state public of protection, and it's a valuable support of the existing of arbitration. I think so. I have one more question to you. When we talk about advantages of arbitration, we enumerate different causes that we all know, and I don't think I will repeat them. However, in relation to this difference between a state court and arbitration court, in some cases we are more interested in choosing the state court, and in some cases arbitration court. What do you think? Digitalization itself, namely in arbitration procedure, will it make arbitration stronger, arbitration strong parties stronger, or in comparison to the state court, will arbitration court will be weaker, considering the fact that digitalization is used in state court as well as in arbitration court?
I think this is a very good question because we believe in the world of arbitration that we are digitizing our processes and our processes will be much faster. But as you pointed out, the state court system is also digitizing, and you referred to initiatives in Russia to make a paperless state court proceedings possible. Of course, state courts are developing as well. We are not competitors, the arbitral system and the state court system, but still, the parties will choose what is best for the interests. And if we look around, we see a lot of modern developments in the state court system. For example, just one example, the Swiss Federal Court will start to accept English submissions in setting aside proceedings in international arbitration, even though English is no official language of Switzerland. This shows how far state courts can go to be, so as to say, user friendly. And in Paris, the Court of Appeal started a panel that will hear cases also in English. It is an attempt to attract additional commercial cases. So we see that state courts are also moving forward, perhaps very quickly. And in the end, the users, the corporations, if they have the choice, they may also decide at the end of the day that the state court system is a reasonable alternative, especially if it offers safeguards with respect to confidentiality and what you mentioned before, data protection.
Well, then, in relation to this, I have one more question. Mr. Aschauer, when you talk about the fact that we will possibly have a choice between two options, between private and public court. You say that state court are more friendly, more user-friendly, related to participants offering better conditions. But actually, this is a fight for jurisdiction. And if this fight for jurisdiction is going to be done with the attraction of all possible resources, and the state has quite vast resources. States with state, I think the same large-scale participants can compete, such as Google, Amazon, and our monopoly companies can also compete in the sense of using resources and in the sense of involving financial flows. And small arbitration courts, the private arbitration courts, which are not completely related to big companies, where the processing was done on brilliant quality of arbitration judges themselves, who considered cases, so to speak, cozy small arbitration cases. Will they survive? What will happen to them? Will they be able to provide the same degree of security and protection? Will they survive the competition with monopolists of higher level? Because when we talk about arbitration at the level of Google or at the level of Russian Sberbank, well, largely speaking, it will not be very much different from the state arbitration. It will not be completely independent. It will be at Google, at Amazon, at Sberbank. And these private arbitration courts, small ones, with their brilliant arbitration judges, what will happen to them?
This is an extremely interesting questions because we see very big players competing against each other, as you say, a Sberbank or other technology corporations. I think in this respect, the big arbitral institutions have a huge responsibility in as much as they have to adapt their proceedings. They can also, as I mentioned, they can also design, for example, safe data rooms, help to make information secure. So here I see a lot of responsibility with the arbitral institutions to monitor proceedings, to make sure that they comply with our standards of fairness and equality, and also with the very big law firms who will represent those big players. They have a different role today as in the past. It is not only about the presentation of a party's case. They become practically data managers and data engineers who work with these sometimes very sensitive data. And I see that in a big law firm, in the meantime, the IT department is perhaps more important than the most brilliant advocate. So this is the change I see coming. And this is a challenge for, as you say, the cozy, smaller firm, but still the modern means of technology perhaps make it possible to compete also if you are very small, provided that you have access to the technology, that you can deal with it, that you can download, that you can pay for the technology, because sometimes it is also quite expensive. But the world is becoming much more complex, and access to justice is one issue. And the other that will be increasingly important is access to know-how. And provided that we have this access to know-how, experience, and education, I think that we will maintain a level playing field, and we can also deal with the cases you mentioned earlier, the Sberbank, Google, Amazon case.
Thank you very much. Yes, of course, it is very important that private dispute resolutions and arbitration would be preserved in their main idea as independent private subjects which resolve disputes. Mr. Aschauer, in your speeches, you several times mentioned the distortion of information or distortion of data. So the question which occurs, if an arbitration court made a resolution based on distorted data or distorted information, what kind of options to correct this defect exist today or possibly will exist, considering another special aspect of arbitration? Because turning to arbitration is paid procedure, and will the person who sees defect in the proof to afford paying for procedure of proving that there was a defect? Is it not going to be too expensive for the correction of mistakes, that in this respect it will make the process of mistakes correction quite complicated?
Um, I think this is a very a good point. Of course, we have a potential for errors, but I believe we would have to tackle these issues with the instruments we already have in our toolkit. If an award contains errors, and those are simply errors of computation, as you know, we have possibility to apply to the tribunal to request a correction of the award. If the tribunal, for example, failed to take into consideration a certain piece of evidence, it is an issue whether the award can be set aside for this reason. Perhaps it cannot. But if a piece of evidence was found only subsequently, a piece of evidence that existed prior to the making of the award, under certain exceptional situations, a party may request, also under current law, a revision of the award by requesting first the setting aside, and then perhaps a new award will have to be made. But as you say, this is an extremely burdensome and expensive procedure. But here we have two conflicting principles. One is the correctness of the award, and the other is the finality of the decision. We have learned to deal with these conflicting principles in a traditional, let me say, paper world, in our traditional economy. And now we must somehow transpose and apply these principles also in a contemporaneous and digital environment. But this should be possible, I would expect.
Большое спасибо.
Well, thank you very much. I would like to say the following thing here. Professor Aschauer, when you talked about combination of these principles of justice and finality, this is actually the balance which is of principal importance, searching for balance. When we were thinking about this issue within the frames of how a state court will behave, thinking about this issue within the frames of our research, we had a problem which was related to the point of error detection, because now technological processes can have a technological mistake. It will not be ill-natured action, but it will be kind of technological error. Then its detection can happen after years or even decades. So, in the meantime, we are at the level of question whether we do have a mechanism which makes it possible, having seen this mistake after several decades, to correct this error. And should it be corrected at all? I think that in this case, we do not have specific answer to this question. that it's a much more private case. In particular, we suggested options to solve this issue. However, the legislator related to state court should consider it, and of course it should be considered by arbitration court. It's out of the question. In your speech, you have mentioned forecast, that it's possible to forecast resolutions or decisions. I would like to ask this question right after your speech, but if I may, I would like to ask it right now before I ask another question. What do you think of forecast of decision? Is it good or bad? Is it dangerous or is it good?
Um, I was referring to situations where an algorithm tries to predict the possible situation of the arbitrator. And perhaps this is what we do very naturally in our daily practice. When we select an arbitrator, we can look into his or her writings and try to anticipate how he or she will deal with the case. This is naturally. I only believe that we have a huge risk when this is done by algorithms with the help of huge computational resources. And if we put together all available information about a person, perhaps we will be able, perhaps, to predict the decision making of that person more precisely than the person himself or herself. And this is a bit frightening, I would say, also, because then as a candidate, you are somehow framed, because if the machine tells the party that, I don't know, Mr. Aschauer is always a pro-document production, you will always be appointed in cases where a party wants to have document production. And then you are framed and you are practically the Mr. Document production, for example, throughout all your life. And this is, I think, a potentially dangerous development. We must seek how we can avoid these issues. I know that in some jurisdictions, for example, in France, there is already a prohibition in place that it's not allowed to analyze the private data of judges for the purposes of outcome prediction. And I think that we should think about possible analogous rules, perhaps also in the field of arbitration.
Лев Николаевич Толстой, наш великий писатель, говорил,
Leo Tolstoy, our famous literator, said that I'm not an animal. I don't have to do everything all day in, day after. We cannot be framed. And it's true that the French people even went further. They prohibited these private data to be analyzed. And I do agree that every person, at least every lawyer, analyzes previous solutions, previous decisions. Maybe they analyze what kind of arbitration they will refer to. Maybe they analyze this judicial practice. But I think it's very important to emphasize your ideas, the importance of free will of a person, which way they will go. It's very important to maintain this free will.
If I may say, the free will is also, and this is a very good point, is also a right to correct oneself. Yeah, and I think a person must be allowed to learn and to make it better in the future. And we must somehow protect this part of our liberty.
I completely agree with you. And a subsequent question arises. If we speak about forecasts for human decisions, speaking about bot arbitration, robot, machine arbitration, is this a reality or maybe some kind of populist move?
Perhaps it's a reality, but if it happens, it is not an arbitration, in my opinion. Then it is a decision made by a machine, but it will not result in an enforceable award, because in the realm of arbitration, it is under most jurisdictions simply not allowed, because the arbitrator has to be a human. And if we look around, this is a requirement under almost every jurisdiction as a matter of the applicable mandatory state law or of the applicable rules of arbitration. For example, there are rules of arbitration which say that the arbitrator, he or she, has to be independent and impartial. And this implies that it must be a human, because only humans have the beautiful quality of being he or she. And then we know that arbitration is a human, and decision making is a human activity. Perhaps the humans may use modern technology to help as an assistant, but in the end, the decision making is the privilege of humans, I think.
I completely agree with your points, Professor Aschauer. If a human being is the ultimate creation in the world, well, probably it is what we have, humans and human relationships. Then when we speak about the issues, if we substitute a machine with a human, we cannot substitute a human with a machine, but a machine can assist humans. And we can use all the resources so that the life of a specific person and the society in general would be much more comfortable. Much more comfortable, but that does not mean that it will be less humanitarian and full of new machines. Professor Schauer, we have a few minutes left, and we tried to stay within the time frame, and you basically cut some corners. Maybe you left out some information from the presentation. Maybe you can add a little bit if you have any strength left, because we have about 4 minutes left.
I think there is, I tried to shorten my presentation. If I have a few minutes left, I just wanted to add and follow up on what you said earlier, that technology can be used in many different ways, and also in a way that makes it easier to have access to justice. I think this is what we should keep in mind. You referred earlier to a possibility to address the state court electronically, to file something to the state court electronically. In our world, where every teenager has a mobile phone, and where one is used to get in touch with other people by mobile phone and electronically, it should be possible and more easier to offer the same, for example, for the state court system. And I believe that, and there have also been surveys in countries where consumer protection is, consumer arbitration is allowed. In Austria, we have practically no arbitration between corporations and consumers. But in other countries, in the United States, for example, this is allowed in some areas. And it was found that consumers are perhaps reluctant to go to a state court, but they are not so reluctant when they simply have to write an email to an association. So we have here perhaps also potential to make access to justice easier. Another example are video conference applications. In former times, it was, for example, for a medium size or a small size corporation very expensive to participate in an arbitration because you need to travel to, I don't know, Geneva, Moscow, and pay for accommodation travel. It's hugely expensive. In the modern world, we have a video conference, yeah? And even a small corporation can participate easily in a video conference. So it makes access, I think, easier. Another issue is simply, as a law firm, in former times, you needed to have a huge library, and that is very costly. Today, we have much of the necessary information just ready. We press a button, and this enables us to compete also with the very big players. And I think here, as you say, and this is the positive, perhaps the positive outcome of our discussion, let us look at it positively and take advantage of the opportunities we see.
I do agree, and I think if we did not have video conference right now, we would not be able to meet and discuss this. That would be very sad. But I think it was very fruitful discussion. In the beginning of your presentation, you said that when people meet in person, they have emotional contact. And this is very hard to do online. But I think we've overcome this barrier. At any rate, the world of our communication is passed on to our audience and obviously to one another. Thank you very much, Professor Aschauer. It was very interesting listening to you. It's great to listen to a person who is deep involved in these issues, both from the theoretical and from the practical sides. And I'm sure that we will meet many, many times more. And the format when two persons from different countries consider the same problems from different perspectives is very valuable, both for those who are engaged in this activity and for those who listen to this presentation, because it's very important for people to have personal communication even online. Thank you very much, Professor Aschauer.
I wanted to thank you for the perfect preparation, the thoughtful questions, and for making all this event possible. I also wanted to thank the translators. I was perfectly aware to follow, and I wish you the very best for the further discussions.
Спасибо.
Thank you very much.